Good morning. Okay, so today we're going to do two things. We're going to talk about a case that illustrates some of the things that we talked about on Thursday, and then we're going to take some of the principles that get drawn from that case, and we're going to talk about them a little more critically. So let me start by telling you what case we want to talk about. So we're going to talk about a case called Walsh versus Lonsdale. Okay, so I'm going to take just a minute and let you guys pull up your notes, pull up the text if you want, search on the internet and sort of get some information in front of you about this case, and then we will have a conversation. So go forth and do. Okay, so let's have a conversation about Walsh versus Lonsdale. Okay, Walsh versus Lonsdale. So let's start by asking, what are the facts that give rise to this case, right? What are the facts underlying all of this?
Good morning, Dr. Curl.
Good morning.
Do you mind if it's read out, or would you just like me to say it off my head?
If what you have in front of you is a text that you want to read, I'm not going to tell you not to do it. So go ahead.
Okay, so the main piece of legislation used would be the Adjudicator Act of 1873, and this is a Court of Appeal case. And in this case, an agreement for a lease of a cotton weaving mill provided for a term of 7 years at rent of 30s. I am not sure what currency S is for per annum.
Shillings, 30 shillings.
30 shillings for each loom of work. If the lessor, that would be Longsdale, provided power steam, the lessee, which is Walsh, not to work for less than 30 looms in the first year and not less than 540 in the subsequent year. It also contained provisions reference to another lease whereby it provided that 1 year's rent in this case, a fixed rent should always be payable in advance on demand. The lessee having been on July 1st, 1897, let into possession, paid rent quarterly up to January 1881. On March 13th, 1882, the lessor served the lessee with notice for a demand for a year's rent in advance. This reckoned at 30 shillings a loom up until the loom he was working on being 560 in numbers. Would you like me to read out the judgment one time, or should I just talk about the facts?
No, just the facts. We're not at the judgment yet.
Okay, so this is the facts, and in regards to the act, it said that with the passing of the Judicature Act of 1873, a tenant in possession under the agreement of a lease has no longer than two estates, one a legal tenancy for year to year, the other an equitable tenancy. Under the agreement, there is only one court and the rule of equity prevails, namely that
Right.
the tenant is in the same position if he were a lessee under the lease granted in the terms agreed. The landlord cannot seize possession of the property by virtue of his legal title if he cannot seize the property under the agreement. And that
Okay.
is in reference to the act, yes.
Okay. So getting a little bit into the law, and that's fine. That's fine. You didn't do anything wrong. But yeah, these are the facts, right? We have a cotton mill. We have an agreement to execute a lease, but the lease never actually gets executed. And there's some complicated calculations as to how much the rent is supposed to be, and these sorts of things. But the key piece of this is that the tenant paid quarterly in arrears up to the point where the landlord demands a year's rent in advance. Okay? So, I mean, have any of you guys ever paid rent in arrears? What does it mean to pay rent in arrears?
I'm not too sure what it is, but it has something to do with you not being able to pay rent later on, like if you fall back on your rent payments to your private landlord.
Uh-huh.
So I'm assuming it's that you're paying in advance in a situation where it comes that you cannot pay it, if that makes sense.
So close, right? Payment in arrears in this context just means payment after the use of the land. So you basically you pay at the end of the month instead of the beginning. Okay. Um, and so you're paying when you show up to pay your rent, you are paying for use you have already gotten. Okay. Um, and the landlord has now shown up and demanded uh, a year's worth of rent in advance. So why do let's sort of think a little more broadly, and there's not, I'm going to ask a question that doesn't really have a right answer. So I want you guys to feel free to just sort of think outside the box and be as creative as you can think of. Anything that's sort of, consistent with the facts that we know will be fine. Why do you think the landlord suddenly shows up and demands a year's rent in advance? He's been getting paid in arrears on a quarterly basis, but now he's changed what he's willing to do. Why do you think that might be?
I can't say for certain, but I'm assuming that he desperately needed that money and to have to demand that he would need it now for now. And it's
Maybe,
actually such a large sum.
maybe, right? Absolutely right. The landlord's financial position might be such that he can't wait uh, for 3 months to pass to get another payment. He needs that full sum now. Um, what are some other reasons that might lead the landlord to make that sort of demand? Right? Go ahead, Summer.
Um, I was thinking that he could also be being disloyal because since there was no formal agreement, if the money is paid in advance and then further on he decides to kick out the person, there would be nothing really in place to stop him from doing so.
Right. So absolutely right. It could be he's running a scam where he's going to claim the year's worth of rent and then in a month or two throw out the tenant on the 6 months notice that he's required to provide on a year-to-year tenant. And by the way, that's basically what Walsh argues is happening here, right? Is that Walsh says, I'm a year-to-year tenant. I can be thrown out with 6 months notice, demanding a year's rent would allow the landlord to throw me out and keep my money, right? So that's basically what Walsh is arguing. Petra says because the quarterly payments were late. Quite, I mean, you're right that they're late in that in the year 2020, everybody pays rent in advance, but it was not unheard of in the 19th century to have a right to pay your rent in arrears, because in particular, right, if you think about where this comes from, leaseholds come from tenant farming, and if you had to pay your rent in advance, you very likely didn't have assets that would enable you to pay rent until you had farmed. So, you know, I don't disagree with you that in 2020 that's a pretty solid explanation. In the 1880s, that strikes me as being perhaps less salient. Not saying that you're wrong, not just that there may be other explanations as well. So, but let's think really broadly, right? Can anybody think of any world events around this time that might change the business of a cotton mill?
I'm guessing the end of slavery, where there's a drastic change in labor, so the industry would be threatened.
Well, I'm specifically thinking of the end of American slavery. I actually think that the U.S. was the last place to still have chattel slavery, but I don't want to be quoted on that because I may be misremembering. But that's more or less what we're thinking of is the disruption of cotton supplies caused by the American Civil War and Reconstruction and the end of Reconstruction at the end of the 1870s. So this is a time of flux for the cotton industry, right? There's a transition, American cotton basically comes off the market. Indian cotton and Egyptian cotton are still available, but prices go way up. And so it's going to be significantly more difficult for a mill to operate. So I think that there's a strong possibility that what we're dealing with is actually a tenant who's going out of business. And the landlord is attempting to obtain payment however they can, right? So what does the landlord do when the annual rent that they demand is not forthcoming?
They're usually supplying a notice to quit once the rent is not coming.
Well, I mean specifically, what does the landlord in Walsh versus Lonsdale do?
Oh, you're talking about, okay, sorry. I just came in late, so.
It's fine. It's fine. So what does the landlord in Walsh versus Lonsdale do? Well, yes, no. He asked for the year's rent in advance. It was not forthcoming. So what was his next step?
He made it specific to the number of looms he worked for. That was in reference to the 560 in numbers.
Well, that was the demand, right?
Yes.
So it was specific to the number of looms that were present in the mill because that was how the rent was calculated. But when Walsh goes, screw you, buddy. I'm not paying you, I'm not paying you shit. You'll pardon the French. You know, what does Lonsdale do? Travis, you went back on mute. So if you were saying something, you should come off mute and say it.
Oh no, sorry. I'm not too sure what he did in that regard.
Right. Try to take his chattels, right? Seymour's absolutely right. Okay. It's a remedy called distress, where you go onto the tenant's property and you seize chattels and you use them to satisfy the debt, right? You may hold them as collateral until the debt is satisfied, or you may sell them to satisfy the debt, but the distress is the seizure, of the chattels, okay? So now we have the factual predicate underlying this claim, right? Walsh brings a claim for wrongful distress. He says, hey, this is not a remedy that you're allowed to use, okay? And what is his argument? Samar, you said it earlier, so go ahead.
His argument was that the leases was not properly signed and therefore the landlord does not have the right to distress.
Right, exactly right, okay? There's no lease, there's only a contract, and without the common law relationship, the remedy of distress is not available. And the idea is, as I said earlier, that he's got this, what he actually has is this year-to-year tenancy that requires 6 months notice. And so the seizure of the chattels is improper, okay? So let me ask you this. Does Walsh concede that he loses if the common law relationship exists? This question is for anybody, so anybody can answer this.
Could you repeat that question, please?
So let us assume that the legal relationship that the contract anticipates, right? The contract says you will execute this lease. The lease is never executed, but let us say, for the sake of argument, that the lease was executed. Does Walsh agree that he loses at that point?
If it was executed, I would say yes, because he agreed to this.
Right, that's absolutely right, okay, is that Walsh concedes that if the contract had been performed as it stated, that he loses, that Lonsdale's entitled to demand the year's rent in advance and then entitled to seize the chattels when Walsh doesn't pay. Okay? Okay. So what does the Court of Appeal say? Let's hear from someone new. Yes, Travis, go ahead. What's up?
The Court of Appeal held that the lessor was in fact entitled to demand a year's rent in advance, but however, not beyond that year. Because as Samar said and as we discussed, it was the agreement and tenancy was created on a year-to-year basis, and thus he did have a right to demand that year in advance payment, but not beyond that year in essence, if that makes sense.
Say more about not beyond that year. What do you mean?
In that he couldn't demand like 2 years in advance, 3 years in advance, or even a month in advance. He had to make his demand based on the time frame of their agreement. And since it fit that year, he could have demanded that. At least that's what it was held by the Court of Appeal.
Okay. So what's the reasoning of the Court of Appeal?
The reasoning would be that they examined it based on their agreement, and that their agreement was made on a year-to-year basis and that time frame, and thus all in the terms of demanding rent in that sense, they agreed to paying of rent. So regardless what was his name, Longsdale would have to pay that rent. So Walsh did have a right to claim that money against him, whether it be for a year, but it's only within that year time period, because he's obliged to pay regardless based on their agreement. If
Okay.
that
Let me correct one small thing and then ask a follow-up one. It's that Walsh is the tenant, right? Lonsdale's the landlord.
okay.
And that was just a misspeak on your part, not a big deal, but I wanted to make sure that we corrected it so that if anybody was going, wait a minute, that they understood where we were. Okay. So here's the follow-up question. Lonsdale has the right to ask for a year's rent in advance. So let's advance the clock a year. Can he demand the second year's rent in advance at that point?
They would first have to, well, at least, not refresh, but agree to continue their tenancy. So once that year expires and the tenancy has expired, so he couldn't ask for the second year based on that year expiring. You'd have to agree that, yes, we're agreeing to continue this for this year again.
So you seem to be saying that Walsh is correct and that what he has is a year-to-year tenancy.
Yes, I would say he does have a year-to-year tenancy, but that means that Longsdale can still claim for the money, for the rent, in terms that it is in agreement or it's within the time frame of that year.
And what about Walsh's argument that in a year-to-year tenancy, it can be terminated with 6 months notice?
Well, for termination and the payment of rent, it would be more that you can't kick him out more than 6 months prior to notice in order to get his stuff and all of that. But in terms of rent, it would be for lack of better explanation, different than completely evicting someone from the property.
So let's suppose that Lonsdale demands a year's payment of rent in January, and Walsh pays it.
Mm-hmm.
And then in February, Lonsdale comes along and says, hey, 6 months from now, I want you gone.
Oh, well, in such a case, then he would have to either be compensated for the time he wasn't spent there, or he would not be evicted. But that would be decided up to the courts and also reasons for his eviction. Because I'm assuming that they wouldn't just evict him with just at a whim. I'm hoping that isn't the case.
Have you ever dealt with a landlord before?
No, no. Although there have been issues where that's possible for Frank's case, I'm assuming and I'm hoping that's not the case. But should that be the case, the court will decide and take into consideration why is he being evicted, and also, well, yeah, why he's being evicted mainly. And then they would either decide to either reimburse him for the money he paid in advance or continue his tenancy for the end of the year. But I'm assuming this will be based on the reason for his eviction.
Does anybody read the Court of Appeals decision differently? Because the other piece of this, right, the other piece of this is that there's no right to distress on a year-to-year tenancy. So the underlying claim is related to Lonsdale's use of distress as a remedy. And even if we agree with everything that Travis has said about sort of the logic of how the court conceptualizes the relationship, Lonsdale loses under Travis's logic. Okay, so Samar, go ahead. Or I'm sorry. Tell me how to pronounce your name.
It's Samar.
Samar. Samar, what do you think?
I think it's unfair, first of all. But I had a question about something else. I just want to say it before I forget. When I was reading up, I'm seeing a lot about equity, and I don't understand where that comes in or how to factor that into my understanding of the case. So if that's important, I would like if we could discuss how that factors in. But in terms of this judgment, I think it's quite unfair. But then it's also a case of like if it happens in the first year and Walsh is aware that in paying in advance he could be kicked out in 6 months, I mean, why would you go back and do it again? Is what I was thinking, because then you're just living with that possibility that anytime that can happen. So why do it again?
Right. Landlords are essentially engaged in a massive, in an industry of terrorism. And I say that knowing full well that some of you may own rental properties. And of course, you're different if you do. You're one of the good ones. So anyway, so let's ask this question, right? Who wins in the Court of Appeal? Does Walsh win or does Lonsdale win?
Lonsdale won in that he was entitled to demand the year rent, but just for that year. He couldn't demand it if it was further. But since he was demanding it for that year, the Court of Appeal held that he won.
Right. He won specifically on the question of whether he was entitled to seize the goods. Right. So there has to be some sort of explanation for why he's entitled to use this remedy that in a year-to-year tenancy, he would not be entitled to use. And Travis is right that the specific relationship between the agreement and the demand is part of the puzzle here, right? In that, you know, Lonsdale's absolutely not authorized under the agreement to demand all 7 years of the rent in advance. But Walsh is also entitled to the whole 7 years of possession, right? Because the agreement is for 7 years. Because the equitable interest that Walsh has is a 7-year equitable lease. It's not a year-to-year tenancy. It is an equitable interest equivalent to the legal interest that the contract anticipates. What's the difference between the legal estate that the legal interest that the contract anticipates and the equitable interest that the contract creates?
Is it because under the equitable maxim that equity looks on as done that which ought to be done?
That is the equitable basis for the court's decision, okay? Because the contract says, thou shalt create this lease, right? This legal interest. That was not done. And so the court says, well, you agreed to do this, and so we're going to treat you as if you had. Okay, that's correct. But what's the difference between the legal interest that the contract tells them to create that they didn't create, and the equitable interest that the execution of the contract creates? Talked about this last week in the lecture. I know it's hard to believe that we discuss anything ever worth knowing in the lecture, but I promise we discussed this.
I'm assuming that in terms of the creation of a legal interest where an equitable interest was formed without it being explicitly said, like as you said, for contracts to create a legal interest where the requirements were that a contract was made, it did in fact create a legal interest and it had specific performance implications in that contract as well. So
well, I'm asking a question that sort of comes prior to that. What's the difference between a legal interest and an equitable interest? Right? Assume that they're otherwise the same. It's the same interest, same grantor grantee, but one interest is characterized as legal and the other is characterized as equitable. What is the difference between those two? Why does that distinction matter?
Legal interest represents ownership, and it can be enforced by law. An owner who has legal
Against
interest,
whom? Who can it be enforced against?
it can be enforced against a tenant.
Anybody else?
I'm not sure if this is correct, but would that be the enforceability in that legal interests would create a right in rem, while equitable interest would have a right in personam, and that it's not enforced against the will, but it's to a specific person.
That's exactly right. That's exactly right. So legal interests are enforceable against anybody and everybody, not even Jesus Christ himself can make a claim against your property if you have legal title. Okay? Equitable title is only enforceable against those who know about it, those who have notice. So these types of contractually created equitable interests are only enforceable against the parties to the contract. So let's consider a slightly different situation, right? Let's consider that in year 3 of the lease of the ongoing relationship between Walsh and Lonsdale, Lonsdale drops dead, and his son Lonsdale Jr. Shows up and demands payment of a year's rent in advance, as under the contract. Is Lonsdale Jr. going to have the remedy of distress available?
I would say that he doesn't, and that even though he would know about it from hearing it from his father, he wasn't knowing in that original
Why not?
contractual sense. And I don't, in that you can't, I don't think you could pass an equitable interest like that, where his son would have a claim in demanding the rent from Longsdale. But however, Walsh would also, his tenancy would also then just be terminated by the death of the lesser, if that makes sense in that scope. But I don't think his son would have that substantial claim as well.
Yeah, I mean, I think this logic is sound, right? The ultimate question is going to turn on, does the son have notice of the equitable interest? And there's nothing in the facts to indicate that he does, except that he knows to make this demand. And so I don't think I'd have a problem with an analysis that either made the inference that he had notice from the fact of the demand, or refused to make that inference, as long as you recognized that the question was, did he have notice, and could you infer notice from the fact of the demand, right? The answer to that question, not very important. The knowing that that's the right question to ask, very important. Make sense?
Yeah, it makes sense.
Great, awesome, okay. Okay, so just to wrap up and sort of to bring it back together, the second thing that I was going to do, we're not going to have time to do, and that's fine. It's not a big deal. The key thing to keep in mind about this case and about the cases that sort of come from it and apply it is that the whole issue turns on where equity lies, right? What is it right to do? And it's right? The assumption is that it's right, it's appropriate, it's just to hold people to the promises that they make. And in this case, Walsh had promised to execute a lease deed that he didn't execute. And so the court said, look, we're going to treat you as if you had executed it with respect to this person that you were supposed to execute it with. And that cuts both ways, because yes, it means that now Lonsdale can demand the rent payable a year in advance. But it also means that Walsh gets the full 7 years. He cannot be thrown out after on 6 months' notice. Okay? And so that is the logic of the Court of Appeals, is that you promised to do this, and we could force you to do it. Like we could enter an order that says, thou shalt execute a deed for this lease. But instead, why don't we just skip that middle step and say, okay, we're going to treat you as if you had executed the deed. And that's the logic of Walsh versus Lonsdale. Okay? So great job today. I really appreciate the engagement and the hard work. Would love to start hearing from folks that we haven't heard from. But, you know, we're still gonna be as you know, sort of open and friendly as possible with this. So still trying not to call on you guys, but let's be let's think about ways in which we can be open to engaging more broadly. So I'm going to let you guys go a little bit early. So I'll see you tomorrow. What questions do you have about this before we go? What questions do you have?
Oh, sorry.
Crystal first, then Travis.
I was going
Go ahead,
to
Crystal.
ask, so that meaning that the judgment was based off specific performance. It's like the landlord can't, well, tenant.
Yes and no.
Landlord can't complain, basically, and be satisfied with but he satisfied the landlord because the same rights that would have been given had it actually been a lease. Had a lease, had been granted, basically. Due to equity. We call equity, obviously, the rules prevail.
The answer is that the question, specific performance is an element of this doctrine, right? This is where this comes from, but it's not contested in this particular case,
Not in this
right? The
particular
parties
case, okay.
stipulate that the contract allows for specific performance. Okay. Then Travis, and then Akil. I see you in the chat. I'm not ignoring you. So, Crystal, does that answer your question?
Yes, sir.
Great. Travis, did you have a question?
Besides the rights and personam, rights and rem part, what are the other differences between legal and equitable interests?
Largely, it has to do with the formalities involved, right? The legal interests require you to jump through the particular hoops to create them. You know, sort of the, you know, say the magic words, do the magic dance, whatever. Whereas equitable interests can be created in lots of different ways, and as long as the person further down the chain of title has notice of them, it's fine, right? So does that answer your question?
Yes, sir.
Great. Akil, to answer your question, I mean, the best answer that I have for you is that the syllabus provides for, that tells you what the assigned reading for a given topic is. To give you some specific pages, it's gonna be, hang on. Yeah, it's starting on page 158, going through 162. So that's the part where we're talking about the Walsh case, and then starting on 163 is where Professor Owusu starts to complicate the Walsh case, and talk about it in a little more, talk about some issues that are in a little more detail. Okay. All right. So we'll let you go at this point, and we'll see you guys tomorrow. So take care. And yeah, this was one of the things that I said on Thursday, is that this chapter gives a lot of detail. It's not necessarily irrelevant, but I will agree that it is complicated. So, okay. So I will see you guys tomorrow.